Good morning, everyone. It is a delight to be here with you. I say good morning because it is 7 o'clock in the morning here in San Francisco where I am. I know that it is later in the day where most of you are. We're delighted to have you here today. We have an excellent panel on investment arbitration and what latest developments, led by our willems member, Laurence KIFFER, one of my good friends at the UIA, and in which we also have Chiara GIORGETTI and Jane Willems, who will be participating. Before we start, I just want to say thank you to all of you for participating this morning. It's delightful to have you here. I hope those of you who have joined other seminars know that I have been very proud of the fact that UIA has been able to adjust to this crazy period that we're all living through. We've had at least 5 or 6 seminars, sometimes more per week. We have podcasts, we have videos, we have a juriste issue dedicated to COVID. We have our newsletter dedicated to COVID-related issues. We've been putting out movies. We have a dedicated part of our website to document collections relating to COVID issues. We've been continuing with our other projects such as UIA Advance, and which is our law firm option, and UIA Mentor, our option for young lawyers. So I can assure you we've been very active these days, and the UIA has been a real source of inspiration and pride for all of us as we go through this period, which maybe there are glimmers of hope and things are opening up, but I'm happy to say some of these webinars will continue because they've been so successful and well received. So with that, I will turn over the floor to my good colleague here, Laurence KIFFER. I wish you a wonderful seminar. I will click off my camera so you don't have to look at me this whole time. And I look forward to hearing a terrific seminar on investment arbitration as we proceed. Have a wonderful time.
Thank you, Jerry. Hi, everybody. I don't know whether I should say good afternoon because we don't know where you are at the moment when attending this webinar, and we are very happy. Chiara GIORGETTI and Jane Willems and myself to present you what is new in investment arbitration. For those who are attending the works of the Arbitration Commission at the Luxembourg Congress last November, it's a kind of follow-up of what I've been told at that time regarding EU influence on investment arbitration. To put it in context, I remind you that the Lisbon Treaty entered into force on 1st December 2009, transferred the jurisdiction from European states to the European Commission on direct foreign investments. EU regulation established in 2012 transitional arrangements for the bilateral investment treaties between third countries and European ones. This regulation entered into force on 9th of January 2013. As from 2012, EU started a process of modification of dispute resolution mechanism in the investment treaties involving EU with 4 countries. You remind that EU entered in free trade agreements with Canada, Mexico, Singapore, and Vietnam. And in those agreements, they modified the dispute resolution mechanisms. Current negotiations are taking place between EU and China, Chile, Indonesia, Japan, and Tunisia. The EU has replaced traditional ad hoc arbitration between investors and states with a more permanent model model of dispute settlement inspired by the existing international courts. and referred to as the investment court system. The investment court systems established under EU agreements are intended to be transitional and to be replaced by a multilateral investment dispute resolution settlement mechanism. To this effect, EU started negotiation within the UNCITRAL Group 3 for the establishment of a multilateral investment court, which would apply to future and existing BIT, including the last step of the EU process of dismantling the former investment dispute the last step of this process, EU process for dismantling the investment dispute resolution mechanism stands in the decision of the European Court of Justice of 6 March 2018, which decided that the arbitration clause in a BIT between an EU member state and third party was not an arbitration clause in a BIT between EU member states was not compatible with EU law. And this decision is referred to as the ACMEA decision. Drawing the consequences of the ACMEA decision, some EU state members undertook to terminate their bilateral investment treaties and start negotiation a treaty. That is the context of what we are going to speak today. In fact, there are two elements that I would like to speak about prior to giving the floor to the other panelists. The first one is the report, the Commission report dated 6th of April 2020 from the Commission to the European Parliament and the Council on the application of the regulation, the 2012 regulation. Indeed, the overall objective of this regulation was to set out the necessary transitional arrangements for BIT's agreement between member states until such time that they be progressively replaced by union-level investment agreements continues to be relevant. For the time being, the EU's reformed approach on investment protection and investment dispute settlement is reflected in the Commission's decision authorizing the conclusion of new bilateral investment agreements of member states with third parties. And in that respect, the Commission announced on 18th of February 2020 its intention to publish all Commission implementing decision on authorization granted to member states for bilateral investment agreements. Moreover, in agreement with Article 15 of the 2012 regulation, the 6 April 2020 report of the Commission provides a description of the regulation and its implementation during the period of 9 January 2013 to 31st of December 2019. I think it's very interesting to see how things moved, the BITs which were authorized by the Commission, the ones which were not. And you will see from that report that several member states have already reviewed or are in the process of reviewing their model text of BIT with a view to replacing all the bilateral investment agreements with new ones reflecting modernized standards in line with the EU reformed investment policy. And in that respect, you can imagine how the EU Commission is pleased that EU member states comply with their new policy. But I would say the most important element of our discussion, or the first part of our discussion, is the treaty, which was entered into on the 5th of May 2020, so at the beginning of the month, whereby 23 member states signed an agreement for the termination of intra-EU BITs. And this agreement is referred as the termination agreement. This termination agreement, of course, implements the March 2018 CEG judgment Acmea case, where the court found that investor state arbitration clauses in intra-EU arbitration, BIT, are incompatible with the EU treaties. This agreement is subject to ratification, approval, or acceptance, and will enter into force 30 calendar days after the date on which the Secretary General of the Council of the European Commission receives the second instrument of ratification, approval, of acceptance. And I shall go through this treaty now for some minutes, just to let you know what is agreed between these 23 EU members with respect to the termination of BITs. In fact, there are two important sections regarding in the treaty. The first one regarding the termination of BITs. There is a list of BITs which are terminated, as well as a list, even in those treaties, there is a will to terminate the sunset clauses on in those BITs. What does this sunset clause mean? It is recalled by the treaty itself. It means any provision in a BIT which extends the protection of investments made prior to the date of termination of that treaty for a further period of time. The idea is obviously to freeze the termination and avoid any effect of the BIT beyond this termination. The other consequence, I would say, of the termination of those BIT, Article 4 of the treaty provides a recognition by the member states, the member states or the contracting parties to the agreement, that arbitration clauses, it is a kind of general statement, arbitration clauses are contrary, the contracting states, parties, accept and recognize that by the effect of this agreement, arbitration clauses are contrary to EU treaties and thus inapplicable as of the date of which the last of the parties to a BIT became a member state of EU. And obviously, no arbitration proceedings are possible under those treaties. I would say perhaps the most important section, although the first one is very important, but it was guessed that such a termination would come, and it was even requested by the state as the consequences of the Acmea case. The important section is the one regarding the claims made under BIT. Because as you know, there are different situations. First of all, there is a new arbitration proceeding. There are concluding arbitration proceeding, and there are pending arbitration proceeding. And the treaty goes through the through those three configurations, if I may say so. Regarding the new arbitration proceedings, the treaty considered as new arbitration proceeding the proceedings initiated on or after the 6th March of 2018, which is the date of the Axmea case. I think it is easier to say it like that. At that, for those new arbitration proceedings, arbitration clauses shall not serve as legal basis for new arbitration proceedings. So for those proceedings, there will be no arbitration, no possible to put in effect those clauses. Regarding the concluded arbitration proceedings, the treaty says that it will not affect concluded proceedings or any agreement to settle amicably the disputes. And the concluded arbitration proceedings are considered that when there is a settlement agreement of a final award issued prior to the 6th of March 2018. Either the award was duly executed prior to the 6th of March 2018, or the award was set aside or annulled before the entry into force of this agreement. In that case, the treaty will have no effect. In fact, the most important section is the one regarding the pending proceedings. And the pending proceedings are the one initiated prior to 6th of March 2018 and not concluded under the definition which has been given before. Regarding those pending arbitration proceedings, there is a duty to inform the tribunal of the Axmea consequences or inform the national courts to ask them to annul or refrain to recognize the decision. But what is very much interesting is the transitional measures relating to pending arbitration. And in fact, the agreement put in place a structured dialogue for pending arbitration procedure. The investor to pending arbitration procedure may ask the contracting party involved in those proceedings to enter into a settlement procedure. Or if the arbitration procedure has been suspended to that effect by the investor. If an award has already been issued but is not yet definitely enforced or executed, the investor undertake not to start proceedings for its recognition, execution, enforcement, or payment, or if such proceedings have already started, refrain from requesting that they are suspended. Settlement may only be initiated within 6 months from the termination of the BIT pursuant the first section that we have discussed before. A settlement shall be entered into if the Court of Justice or National Court has found in a judgment, which is final, that the state measure contested violate the union law. And on the contrary, no settlement is possible if the state measure does not violate EU law. What you can see from the first provisions that there is a kind of incentive of the investor to solve to put an end to the BIT procedures. And you will see from the the Article 7 that the settlement procedure shall be overseen by an impartial facilitator with a view to finding between the parties an amicable, lawful, and fair solution out of course. The facilitator is designated by common agreement of the investor and the counterparty and the contracting party, sorry, and there is a development of the treaty regarding the dialogue which be put in place between this facilitator and the parties in order to find a solution. I think I should not go further. I think I gave you the most important lines of this treaty because I would not like to prevent my colleague to go ahead with the other new aspects of investment arbitration. The follow-up, the next presentation is made by Jane Willems. Jane is representing the Asian Academy for International Law at the Untitled Group 3 on the new investment dispute resolution mechanism, and she will explain you what is the last developments in these works. Please, Jane, you have the floor.
Thank you very much, Laurence, and thank you for the kind invitation to present at the International Arbitration Commission again. A warm welcome to all the colleagues. I see many of you are sending us greetings in French. My apologies. This will be in English. The presentation, mais chers confrères, j'espère que vous vous portez tous bien. The Institutional Working Group 3, as many of you are aware, is focusing on a possible reform in the investor-state dispute settlement regime. And I'll move to my next slide. Yes. And it's been working for the last 3 years very intensively on first reviewing whether a reform would be possible, and then focusing on concern that have been identified. In this respect, the EU, the European Union has been, as an observer, very active within the working group to identify not only concerns, but to offer active solutions to the concerns it had observed in order to start off a potential reform. In 2018, the session identified and focused on 6 main concerns that had been identified also by state members, participants to the commissions, and finally decided in early 2019 that it should go ahead by consensus and start a reform, and found that that reform was necessary. The EU has identified a few concerns, and I've highlighted in red the ones I will focus on today for the purpose of the presentation. The big criticism that we see and that Laurence was referring to is the lack of a permanent body to adjudicate investor-state arbitration, investor-state claims, and that the pending process is an imported arbitration procedure from commercial arbitration, And it considers, the EU has been considering that so-called ad hoc system, be it ICSID or be it ad hoc tribunal, and that means not a permanent body, has created and has a considered impact on creating inconsistency, and lack of predictability on the content of the law. It has also raised concern on the perception of the system, on the limited possibility allowed by the arbitration system to remedy for lack of correctness or inconsistency in the decisions that are rendered. It has also raised concern on the nature of the appointment of the adjudicators, on the significant cost involved in investment arbitration, and the lack of transparency on the process. The Institutional Working Group has in turn confirmed the 6 areas of concern that it will focus on in the decided now reform, and the areas that should be the members should focus on. Costs, arbitration costs, and in particular cost for the host state, the duration of the proceedings, which ranges from 3 to 4 years just for a first instance procedure, and the question of the consistency and the notion of correct decision or incorrectness of the decisions rendered, and also questions about the arbitrator status, both their appointment mechanism, the question of diversity in the appointment, and also the independence of the arbitrators and ethical issues that are raised, that may be raised. The element of a possible reform range on possible reform, systemic reform, by opting out from a arbitration ad hoc mechanism to a standing multilateral mechanism. So there are different views that are exchanged currently at the working group. Last meeting in January was the first time where observers and participants exchanged views. Well, to put it briefly, the EU and the EU state members that are members of the group promote the establishment of a standing multilateral mechanism. At the other end of the spectrum, other states like Japan, the United States, and others do promote a statu quo. Of course, the system could be made better, could be improved, but the arbitration system as such doesn't contain any such problems that it should be totally opted out. And in between, you find states who would allow for some type of possibilities. What could they be? Well, a review of the arbitrators and the adjudicators' appointment methods and ethics. Also, the third party's involvement in the possibility to interpret the treaties to which they're parties, the possibility to include pre-arbitration dispute resolution mechanisms such as mediation, possibilities, and an improvement in cost management and transparency in third-party funding. I have highlighted something that is yet being discussed this month through webinar that you can find actually on YouTube on the website of the Work Group 3, is the mechanism, how, if we get those reforms in, those solutions in, how is this going to be implemented? What will be the framework? It's an interesting, I'll go on my last slide about how it could be implemented and what is being discussed. This is a much discussed opt-in convention on the appellate mechanism that has been suggested by some scholars. Here is the agenda. I won't review this, what was done, but Just in January, for the first time, we went to the core reform. We went to the appellate mechanism. We went through the possibility of a multilateral investment court, and the EU submitted a working paper on the question again, and the works of the discussions leading to on that week of work, including the question of the selections of the arbitrators, is found in what we call working paper 1004, is the document where you will find a summary in 21 pages of what was discussed. What was to be discussed in April in New York did not take place. It was dispute prevention. We will see when the meeting will take place, and if it takes place maybe in the summer. We have no news for the moment. But let's turn actually to the elements of a possible reform. And the most discussed question of what type of inconsistency or what type of consistency issues do we find in investor-state award, be ICSID or ad hoc award that are rendered at the moment. Well, one of the major concerns that states have highlighted at the work group 3 is the question of inconsistency in the interpretations of some of the provisions of bilateral investment treaties. Some of the substantive protections that are provided in the bids do lead to, sometimes when they are identical in the same bid, to different or divergent interpretation. Sometimes similar provisions in different bids also are subject to divergent interpretation. Or else similar provisions with similar underlying facts in parallel procedure lead to the assessment of the merits on with different outcome. Let me highlight three instances where we have found inconsistencies and where writers have highly commented those inconsistencies. The first instance has to do with the substantive protection under the full protection in security. One example is found in two cases, two arbitral awards, both in situ arbitral awards that were rendered in two cases where the same bit, the same provision was interpreted in turn by two arbitral tribunals. On the right of the slide, you find the first arbitral award rendered in 2007. The question was the interpretation of the scope of the word protection and constant security. Does that standard include something that is beyond the physical security of the investors and its assets? And can we go beyond this and actually include in the protection the changes in the regulatory framework of the host state, so that the changes that would dismantle the existing framework at the time of the investment would be contrary to the notion of protection and constant security. Legal security was found to be within the scope of the interpretation of that standard, and the claimant's claim was welcome. But 11 months later, in another tribunal, interpreting the very same bilateral investment treaty protection, that very term, it found that the investor's claim should be rejected because it would be inappropriate to actually depart from the traditional concept of protection and constant security that would only include physical security and investors, so the legal security wouldn't be included. So that's that type of inconsistency that's been pointed out. Now, there are many of them, but these are flagged circumstances where the responding state, if it's facing multi-claim under the same bid, under the UK-Argentina bid, may wonder, well, what is the scope of the protection I'm offering, and what are arbitral tribunal willing to include in terms of interpretation of the treaty as a scope of the protections that are provided. Another example on protection and constant security. Sorry, I'm slow because has to do with two parallel procedures with same underlying facts, where two investors in the same chain of ownership sued the same host states. This is the well-known case, Loader CME versus Czech Republic. Two parallel procedures that were not consolidated, and similar protection as you see on full security and protection. On the one hand was found that it did actually include from the state. On the left, you see the decision, the duty to exercise a due diligence. So actually, in that case, the investor's claim was rejected. Well, in the other case, the same standard was found not to include a duty of due diligence, so that actually the standard would amount to a strict liability and absolute liability. So in the same underlying facts, the same claim, the investor prevailed in the first instance, and it did not prevail in the second instance. So this gave, again, an illustration of inconsistency and the powers of arbitral tribunal without any control on the correctness or on the consistency or any will to apply a principle of consistency in the awards that are being rendered leads to major concern by state members. Let me look at just another element, just to illustrate real quick, is the standard, the well-known standard of fair and equitable treatment, whether it's independent term as the bottom, and we have a low liability threshold if we consider that what is included as fair as a breach of fair and equitable standard may be any unreasonable or behavior that lacks a sense of fairness or reasonableness. But at the highest standard, it is coupled with a minimum standard of treatment under the customary international law, and there it's a very high standard, often triggered under the near decisions, where actually the violation must shock or be a violation that is egregious. So it was applied. Some different arbitral tribunals have applied different threshold standard in order to trigger the liability of the state, yet sometimes with the same wording of fair and equitable protection. So with that in mind, where do we move? What do we have available in terms of correctness mechanisms to correct the awards? Well, under the exit arbitration mechanism, there is the possibility to seek before the ad hoc committee an annulment of the procedure. But let's look at what the ad hoc committees have indicated. They've indicated that the committee, in the case at hand, had identified in the award that was submitted to it for review a series of error and defect. The award contains errors of law. The award and suffered lacuna and illusion. But at the bottom, the tribunal or the committee found that it could not simply substitute its own views of the law and its appreciation of the facts to those of the tribunal. So available at exit at this time under Article 25 of the exit, 52 of the exit convention, there is no mechanism to correct the misinterpretation of the law or of the bid, and there is no mechanism to correct a misapplication or misappreciation of the fact. If we look at the non-exit mechanism, so that's the state court judicial review. Apologies, I missed one slide. Trying to go back one slide. The so-called ad hoc mechanism, because it's non-exit mechanism, if we look at an institutional jurisdiction where an arbitral award is rendered, the state courts on the left only provide an annulment regime that is based on judicial review. That is the review of the integrity of the process. The annulment procedure, the setting aside procedure, the recourses do not aim at providing mechanism to correct the interpretation of made by the application of the law, made by the judges, made by the arbitrators, or the correctness of the fact. I just left out jurisdiction because there is a de novo review, and Laurence, you know very much about this because you were involved in a famous piece on this. And failure to state reasons by the arbitrators may be a ground to review some part of the merits. But what is opted, what is discussed at this moment is the right part. Is do we open an appeal mechanism, an appeal regime to review the correctness of the decision? A second instance that would top up either ad hoc awards or exit awards. The same grounds as the annulment grounds or the Article 52 grounds would be available to the parties, and we would add 2 grounds. Then the question would be, can the appellate mechanism, can the appellate court review errors of law or clear errors of law, or can it go into the facts and review errors of fact or serious errors of fact? This is what is being discussed. What is the ambit of the review of the correctness? So that appeal mechanism has been expanded, as Laurence was telling us, to the new investment court system. Moving to the next slide. And the proposal made by the EU. The proposal includes both a permanent body and an appellate mechanism. A first instance tribunal, an appellate tribunal composed of full-time adjudicators who would review the cases. And the question is the funding, of course, of this that type of institution. That is what is being discussed, the funding for this institution, and coupled with a joint committee of members, of panelists, who would have the task, just like the NAFTA treaty mechanism, to issue what we call joint, what we call advisory. This is what is being discussed. So I see my time is up, Laurence. Thank you very much. I hope this was helpful. There are 2 more slides, but you can watch them later after the presentation.
Thank you, Jane, for respecting your time and leaving some time to Chiara to present us one of the, I would say, new goal also of EU to get adjudicators Essex. And in that respect, you will present us the draft code for the draft code prepared by ICSID and UNCITRAL for adjudicators in investor-state dispute settlement. Chiara, you have the floor.
Many thanks, Laurence, and many thanks for the very kind invitation. And to Jane also for a very interesting and complete background on what is going on in the Working Group 3. Now, as Jane suggested, together with very systemic additions and changes to the ISDS process, there have been also discussions to do more specific changes and just deal with some specific problems that have been identified as problematic within the ISDS system. And one of these issues has been arbitrators and how to guarantee the independence and impartiality of arbitrators, and the fact that arbitrators, because they act in an international setting, they do not have a common code of conduct. So many contracting members of UNCITRAL have requested the working or the drafting of a code. Now, in the 38th session of the UNCITRAL Working Group 3 in October, UNCITRAL and ICSID were mandated to draft a code, and contracting members also sent several comments on what should be contained in the code. The draft code has been published by UNCITRAL and ICSID on May 1st and is now available on their website. I was very fortunate to be a scholar in residence at ICSID, and I have been working on the drafting of the code. And I will offer now a little bit really of an overview of the code. Just to start with, so what we have now on the screen is the draft code, what is now public from ICSID and UNCITRAL. Now you will see that in this document, which is also available in your document section, in the handout section, there are two versions of this code, one with comments that explain why the provision was drafted in a certain way, and then in Annex 1 you only have the code with the provision themselves. You also have an Annex 2 that reviews the existing codes. There is a code in, for example, CETA and in the CPTPP Treaties 2. The code is, as I said, is a draft and it is available for comment. So ICSID and UNCITRAL has also opened it for comment. The code itself has 12 articles, so it's very brief, and it is a code of conduct for adjudicators and only for adjudicators. So it is meant to be a flexible code that whatever happens in the future with the reform of the ISDS, whether there's going to be an appeal mechanism, whether it's going to be a permanent court, this code may be applied to all form of adjudicators. So arbitrators, judges, appeal members, ad hoc members for ICSID annulment proceedings. So a flexible provision that was a flexible term that was used for this purpose, and but it is only addressed to adjudicators. There have been requests also to possibly regulate the behavior of counsel or experts or members of secretariats. This is not what is contained in the code. The code is only for adjudicators, and the code of conduct for adjudicators is very much mirrors what other codes have included. So as I said, 12 articles. The first two are very much a introduction. So the first Article 1 contains a series of definitions, and Articles 2, the application of the code. When does the code apply to ISDS proceedings? Article 3 provides a series of general duties, which are also similar to what we find in other codes. And now I want to, if it's possible, to go down. Yep. Okay, sorry, thank you very much. So as you will see, there's a commentary here, also an introduction, and then a commentary on the code itself. So Article 3 provides an overview of the code and starts from the fact that adjudicator must be at all times independent and impartial as specified in Article 4. So Article 3 provides a framework which is then specified in Article 4 to 9. Article 10 and 11 regulate pre-appointment interviews and issues of fees, and Article 12 addresses the issue of enforcement of the code. In the handouts that you have in the document section of this webinar, you also have a commentary that I wrote for the Kluwer Arbitration blog that provides a little bit of a general review of the code itself also. So I would like to, Article 3, as I said, provides a general view, and then Article 4 defines what the terms of, what we mean by independence and impartiality. Let me see if I can. I'm trying to scroll down the code. I'm sorry that this is taking me a little longer than what I expected. But I would like to, while I try to find the provision, the code itself is centered to the idea that arbitrators are required to disclose as much as possible. So Article 4 requires adjudicators to disclose, sorry, I said arbitrators, but of course I meant adjudicators. So Article 5 requires adjudicator to disclose, and this is kind of a key policy issue to ensure that there are no conflicts of interest. In what we have, what ISDS contracting members and critics of the ISDS proceedings have identified several issues that have created this call for the code. One is the idea of repeat appointments. The other, or multiple appointments, the issue of issue conflict and double hatting. These are all complex policy questions that are addressed in the code itself. But the central idea of the code is to require adjudicators to disclose as much as possible so that the parties are aware of what the adjudicators has done, the relationship of the adjudicators herself, and to see whether they may want to stick with that adjudicator or possibly maybe try to remove him or her through a challenge proceeding. Article 11 and 12 also provide the enforcement and what are the way in which, what are the mechanisms of enforcement that exist in the code itself, which are mostly centered on challenges. What you will see is that Article 5, and I would like to spend a little time on Article 5, is drafted so that the contracting states can decide how stringent or not those disclosure requirements should be. So if you go in Article 5.2, for example, so disclosure are to ensure that adjudicators don't have direct or indirect conflict of interest. In Article 5.2, you'll see that the adjudicator has to disclose professional, business, and other significant relationship, and contracting members can decide whether they want to include a time constraint, so for example, only in the past 5 years or not, whether they want to include not only the parties, but subsidiaries, parent companies, or other agencies, and whether they also want to include, for example, in subparagraph 2A4, third party with a direct or indirect financial interest in the outcome of the proceedings. So this code is a draft that allows really contracting members and unsure when the delegates will go and discussion will resume to decide certain specific policy issues on how stringent and how these obligations and disclosure procedures would want to be applied to adjudicators once the code is approved and is enforced. In terms of what the adjudicators are required, as I said, they have to disclose kind of as much as possible and what specifically will be for the delegates to decide. They have to be proactive, so they have to make sure that they research that what the any possible conflict of interest, and this disclosure is also continuous. Article 5 also, if we can enlarge it, yeah. Article 5 itself also addresses two other of the criticisms of ISDS. One is the issue of repeat appointments and multiple appointments, and the other one is the issue of issue conflict. I hope that you can see in the second part, in the last part of Article 5, so the issue of repeat appointments, disclosing all the appointments. Perfect, actually, no, just the end. Colette, if you're working on this, just the final part of Article 5. The idea of issue conflict also. So Article 5 also looks at repeat appointments and issue conflict. Repeat appointments has been an issue because there has been a criticism that on one side, adjudicators may be too busy. On the other side, the repeat appointments may create an uneasiness. Too many known arbitrators are always they're always the same people that get reappointed, and that may create some relationships and possibly some preferences for a certain party or for a certain of a certain view. So Article 5 provides through disclosure provides a response to the issue of repeat appointments also. In the last paragraph of Article 5, we also talk about issue conflict. Issue conflict is another issue, is another criticism that some have made to adjudicators and in general to the ISDS system, saying that some adjudicators may have already prejudged certain elements because they have already decided possibly in another award or in their writing or publication. So they wouldn't come with an open mind, but they would come with a prejudgment. This is called something that's called issue conflict. And what the code requires is a disclosure of all the publications and possibly also public addresses. Again, this is an issue to discuss, to be discussed by the delegates. Very briefly, because I know my time is almost up, I would just like to point to Article 6, because that addresses the issues of double hatting, which is another criticism that adjudicators in ISDS have sometimes received, which is unique to ISDS. Some people are both counsel in certain cases, arbitrators in others, and Article 6 is formulated again to give policymakers a range of options, again based on disclosure. Have adjudicators, proposed adjudicators served already serve as counsel, serve as adjudicators in other cases? What cases create a double hatting perception or problem? Is it only for other ISDS proceedings, or is it for all international arbitrations or for all international proceedings? So very much an issue that needs to be discussed at the Untitled Working Group 3, and the code provides a possibility, several options for the delegates to decide. I want to close because I see it's 10:59 already, and I know we are almost up. But just talking about Article 12 and enforcement, the issue of enforcement is another important issue. There is a limit on what arbitral institutions can actually do, and the main enforcement procedure will be the challenges. There have been discussions to possibly also do something else, but it's very difficult, and this is another issue that can be discussed. There have been discussions about possibly a list of arbitrators that are, or adjudicators that have not been that are not in compliance with the code, or possible fees, but it's impossible to implement at the moment. The other issue is implementation of the code and how the code is going to be implemented. But for this, I will remind you to, I will just refer you maybe to the commentary of the code itself and to the Kluwer arbitration. But I would like to conclude just by saying thank you again. And this is a draft, so if you're interested in providing comments, both the ICSID Secretariat and the Untitled Secretariat are open for comments. Maybe the UIA may want to draft something, or others. But thank you, and I hope this has been helpful, and I look forward to possibly chats.
Thank you very much, Chiara, for this interesting and complete explanation of the draft code. I should have tell the participant that they could put questions on the chat section, but I understand that some did, but there are no questions regarding our presentation. Can we just have 2 minutes more just to see whether participants have questions that we can reply? Alors, on me demande, I'm requested whether there is my presentation is accessible, and I shall give it to Colette, and they will be sent to the participants at the same time that they will receive the audio, the recording of the session. No, I don't think there is any other questions. So let me thank the participants for having listened to us, and thank you to Jane and Chiara for their presentations. Thank you. Bye-bye.
Thank you. Bye-bye.
Thank you, everybody. Bye.